folks, and welcome back to the Summity Masterclass. Hope you're all doing very well. And welcome back to part 2 of reading through Carlton Weiss's concise trustee handbook, which, those of you inside the course have a link to in the Dropbox below. Those on YouTube, obviously, I'll put a link below for you guys to download and read through in your own time. We've obviously gone through a lot in the first part, so if you join in this video at part 2 and haven't gone through part 1 yet, highly recommend going back, watching part 1, get caught up with all the things that we've covered in regards to, what is a trust, why is it so powerful, trustees' powers, and what is actually happening on this planet as well, like a bit of backgrounds in regards to the jurisdiction that they're pulling us under, away from God's law, natural law, and why an entity like this, when you set it up, a private express trust, will afford you the protections under the common law, which is linked to the law merchants. Okay, that's the closest thing that's going to allow you to have that screen to protect you, the natural living being, to be able to use that entity to operate in commerce on the public side, but still stay protected on the private side. Okay, and we obviously I ran a lot of commentary on the first part based off of a lot of things that were covered by Carlton Weiss, which he obviously explains very well and paints a great picture as to the context of why such trust is so important to have. In regards to asset protection, estate planning, and also your status correction within this game, and so hopefully we'll go through obviously part 2, and this will just help build on part 1 and give you even more resources and reasoning behind why it is very fruitful going forward to learn these things and actually eventually have one set up, okay, as part of your whole estate planning portfolio. All right, so with that being said, get comfortable, let's dive straight into it. I will try not to repeat myself because obviously I went off on a lot of tangents in part 1, but like flogging a dead horse, sometimes it helps to repeat these things, repetition, rinse and repeat, in order to emphasize some of the key points as to why we're doing what we're doing, why it's so important for us on this journey, anyone who's on this journey, to really come back to life, come back into the knowledge of what our ancestors used to know in terms of being able to put pen to paper and administer our own contracts and our own estate behind these trust entities, okay, and also 508c1a ministries, which is something that I also want to keep highlighted and keep in mind while still going through and dissecting this express trust, because another really powerful entity is the 508c1a. Okay, and again, as we broke down in the first video, it's all trust law, everything is trust law. The governments are otherwise operating an express trust. Okay, the executor should be us, we the people, as our strawman, directing the trustees, which are the men and women who are holding an oath of office and fulfilling these roles in these departments for the benefit of us, the living men and women. Okay, but as we know, what they do is they get us to subrogate and they get us to pin our strawman as trustee, which then has to perform as part of the express trust, where the executor is the state, okay, the government, or when you're in court, it's the judge, and the beneficiary ends up being the state, which is what they use and have set up our Social Security trust account or National Insurance trust linked to our City KB trust in our name in order to capture that for their benefit, okay, which ends up being the state's beneficiary. Okay, and this is what we want to try and come out from, being subrogated under their tricks and traps, and understand what is happening with these roles within trust law. Okay, so you obviously have, in the corporate sense, just to recap, you would have the directors of a corporation who want to come together and set up a corporate bylaw and charter, terms and conditions of what they want to administer, what this corporation is going to be about, which will then direct the employees, which are otherwise the trustees in trust law, to perform for the beneficiaries, which will otherwise be the shareholders. Okay, and you can think of a church, when you come together and set up a 508c1a, for instance, you'd have the president or the founding directors who would then put together the bylaws of the church, which is otherwise just the trust indenture, and then you can have, as a trustee role, would be the secretary and or the treasurer, okay, for if it's a private member association, for the benefit obviously of the world and of the people and of the members who otherwise donate, the donors, okay, of who donate into the church. And as you'll see, like I said, I'll probably put a video together to break down in comparing the express private trust to a 508c1a ministry. And like I mentioned in the last video, it's of my belief, where I sit right now, the knowledge I carry about these two entities, is that the 508c1a is very, very powerful and a lot easier and more efficient to administer and function in regards to the express trust. And there's a few points that I'll break down, one of which is it hasn't got laws of perpetuity against it. It can exist in perpetuity and not have to be, unwound and then start back up again every 20 years. And you also have less paperwork. There's no tax filing requirements each year. And it's actually an entity, the only entity that I know of where you can actually register it in the public and have it recognized by the state in America and internationally under the Hague Convention if you get those documents apostilled, right? Without needing to have any tax obligations or filings and automatic tax exempt status. Okay, so it's truly a very powerful entity which you can operate very similar to an express trust. The only difference being you're dealing with donations rather than selling the beneficial interest into the trust when it comes to exchanging assets and putting personal or real property into the church as compared to express trust. Okay, but I'll do a separate video breaking this down just to highlight that, but just keep that in mind going forward, because obviously we've got so many different vehicles out there in order to kind of achieve the same results of asset protection, estate planning and status correction purposes. Okay, right, let's dive straight into this, pick up where we left off, which is powers and duties of the trustee. So the powers of a trustee are divided into three categories. We've got general, special and discretionary. The general are all those inherent in trustees, virtute officii, i.e. ordinarily conferred by trust law. The special are all those conferred by the trust instrument, and the discretionary are all those arising out of the necessity of personal judgment, though broad discretion may also be conferred by law and as well as by trust instrument. It is well settled law that under a declaration of trust, the trustees must have all the powers necessary to carry out the obligation of that private contract which they have assumed. Furthermore, it is settled that the trustees of an express trust are afforded greater latitude to carry out their duties than ordinary trustees. The trustees are empowered to control every aspect of the trust according to the trust instrument and equity, and retain the power to remove even the beneficiaries from the premises. These powers include, but are in no way limited to, the power to bind the trust in a contract, especially where such obligation is implied by law, and the power to contract with the beneficiaries. The power to partition, exchange, sell, pledge or mortgage the trust property, either in whole or in part. The power to lease trust property. The power to issue, change or otherwise dispose of securities of the trust. The power to support the beneficiary in all reasonable manner. The power to prosecute and defend in the trust's name or trustee's name. The power to make gifts out of trust property. The power to delegate all unessential powers and duties, and the power to exercise personal judgment and every discretionary power not prohibited by the trust instrument. He may do whatever a man or woman may lawfully do according to a natural right. The fundamental principle of law is that for every power there is a correlative duty. The trustee, as a fiduciary to the beneficiaries, assumes certain basic duties outside of the management of trust property and other general duties aside from whatever specific duties may be conferred upon the trustee in the trust instrument. These duties include, but are not limited to, the duty to support the beneficiaries in any essential needs which it may have out of the funds which would otherwise be paid to it in distribution, and if such funds are not available, the duty to accumulate any balance needed. Again, it says here, footnote number 69 that I've highlighted, see Loring. The trustee's fealty is to the trust, and all his acts must be governed by strict loyalty to it and the interest of the beneficiaries, and any act which is not in the interest of the beneficiaries is a breach of trust. Okay, it's pretty self-explanatory there. The duty to refrain from taking advantage of peculiar knowledge or position when dealing directly with the beneficiaries. The duty to exercise the utmost good faith in all concerns of the trust, whether dealing with the trust property itself or directly with the beneficiaries in matters concerning the trust, including to care for, protect and secure the trust property. The duty to preserve, protect and further the trust interest according to the purposes designated in the trust instrument, including pressing all reasonable demands and prosecuting and fending off all claims and claiming all available exceptions and taking all available remedies and advantages in trust matters. When delegating unessential powers and duties, the duty to exercise at least a general supervision of the trust affairs and to perform any ministerial acts which require the exercise of discretion or judgment. The duty to keep minutes and separate accounts of the trust even if kept in a book with other accounts, with minutes showing decisions and resolutions reached, an account showing the state of the trust and pertinent details of transactions, generally in the form of schedules of income received, income paid, additions to principal, deductions from principal, principal on hand, and changes in investment, consisting of debtor and creditor sides. Upon acceptance of the trusteeship, the duty to secure and protect the trust property and trust documents. When investing trust funds, the duty to invest them securely so that they shall be preserved intact for the remainderment, and to invest productively so that they shall yield at least the current rate of interest to the life tenant, and the duty to concur with all co-trustees except where authorised to act individually. Okay, and there's obviously a lot of footnotes there, guys, that I won't waste time reading through, that you can read through in your own time when you download the PDF or get it printed off, which I highly recommend getting a hard copy of as well, keeping it safe for your benefit to go through in your own time. So let's carry on. Next chapter, privileges and liabilities of the trustee. Carlton says, in addition to powers and duties, there are certain privileges, including allowances, rights and liabilities of the trustee. These are all those which are enumerated in the trust instrument and naturally extended to the trustee of an express trust. As was noted earlier, certain restrictions placed upon trustees of ordinary trusts do not apply to the trustee of an express trust, pursuant to the doctrine of greater latitude. These, aside from those allowed by the trust instrument, include, but are not limited to, the inherent unquestionable right to full compensation, including reimbursement of all out-of-pocket and other expenses incurred in the discharge of duties. An unduly withheld reimbursement results in a lien on the trust for the amount plus interest. Okay, so compensation, there in another document that I put together inside the course, available to my sovereignty members, you will see that under a court case, it was deemed from the IRS that any person holding a trustee title for an express trust compensating themselves up to $500 is seen a reasonable amount for them to be able to receive and to pay themselves for administering the trust, which is tax exempt. Okay, so keep that in mind. That's obviously quite a bit of money if you're holding res in the trust and the corpus, right, and benefiting from the income that's, or the profit that's being produced from that. You can pay yourself as trustee up to the value of $500, and you won't raise any eyebrows from the tax agencies, okay, because that's considered in the court case to be a reasonable amount in that sense. Right, so the privilege, carry on, the privilege of residing within the trust estate and allowance of rates and taxes, although he, the trustee or she, has the benefit of residing in the house. The right to employ a solicitor for assistance and guidance in the administration of the trust, and in the case of any doubt or difficulty, to seek the opinion of competent counsel, and in the case where the trust accounts are intricate and complicated, to seek the assistance of an accountant to the charge of the trust. The right to apply to a court of equity for directions in the execution of the trust, or to obtain a declaratory judgment in order to establish the meaning and intent of the trust instrument. The right to carry on in separate business for the benefit of the trust given certain conditions. The allowance of remuneration for loss of time under certain circumstances. The right not to be compelled by subpoena or review to produce and show records or books to outside parties. The right to further limit his liability in particular contracts, even beyond the limitation made in the trust instrument. The right to relocate, move trust property, or change the trust domicile. And the inalienable right to disclaim the office at the execution or resign at a later date. Okay, so these are just expressing some of the powers, privileges and liabilities that the trustee has, okay, which is again pretty self-explanatory. So with regard to the personal liabilities of a trustee, basically the inherent liabilities and non-liabilities are all those incident to ownership at law and imposed or exempted under contract law, for it is a maxim of law, which I'm probably going to butcher this, but le contrat fait la loi. Okay, if we go down to footnote number 84, he says the contract makes the law. Okay, that's what it means, that legal maxim. See generally Bouvier's Law Dictionary, okay, pages 770 to 790, 1928. The basic principle is that all man's law is contractual in nature, regardless of the particular classification of law, and can acquire force only by consent. Okay, and then there's another legal Latin maxim there. So all law is consent which means all law is contract. No valid lawful contract, then there is no agreement, there is no law that can be enforced upon it, unless you're ignorant. And that's where they fleece you. This bilateral, unilateral system they set up, okay, unilateral contracts, as we've gone through the previous video. So we shall continue. Therefore, a trustee's liability is largely determined according to the particular circumstances of the situation, especially contracts wherein the trustee has properly limited his liability by qualified signature. And he goes on to say, I will discuss the principles of and procedure for properly qualifying one's signature in a later section. Okay, to make sure that you have limited liability and identified as a trustee. For now, we will entertain the general liabilities, which may include, but not limited to, liability on all contracts made, whether signing as trustee or signing individually, liability of removal for breach of trust, waste, mismanagement or good cause, shown in an action for removal in a court of equity or according to trust instrument, liability for losses sustained by the trust as a result of negligence, liability for torts in common law, criminal and civil wrongs or acts of bad faith, liability in all cases of commingling of trust funds, and liability for all mischief of his agents contracted to exercise discretionary powers. Okay, and if we just look at footnote number 85 here, which is liabilities on all contracts made, whether signing as trustee or signing individually, it says here, see Loring, simply using the title trustee will not sufficiently limit liability in certain contracts, such as debt instruments and agreements, which fail to specify the non-personal capacity of the trustee. That without some express stipulation he is personally bound is well settled law. Okay, so it's important. He'll obviously show you later how to go about signing, the particular contracts when you're acting as trustee on behalf of the trust to make sure that you have got that limited liability and protection in place. Now, I have inside the course, if you look at the other videos, the breakdown of all the trust templates, there is also a hold harmless indemnity agreement you can fill out on behalf of the trust with the trustee in order to hold it harmless and indemnify it, okay, which is linked to these indemnity bonds also. But when we step into this role, if you wanted to become a trustee, you can't be double-minded. You must now live your life for the rest of your life as a trustee and autograph everything you do in that sense, okay, to save confusion and inviting jurisdiction and, doing something that would otherwise create a chink in the armor of the trust, where, you can maybe fall under their jurisdiction again. Okay, so it's important to make sure you're doing everything in your power on behalf of the trust as trustee to make sure that you're advertising to everyone else in the public world that is the role you're taking, that is the mask you're wearing within this theatre of commerce. So we continue, but the trustee is not at all liable for any losses sustained in the proper discharge of duties. And in the case of other losses due to negligence or tort, the trustee may be able to be bonded in the manner ordinarily used by executors and administrators. Okay, we just got another one here to see 89. Okay, liability in all cases of commingling of trust funds. It says here, generally in cases of commingling of the trustee's personal funds with trust funds, courts will follow the trust property, unless commingled beyond separation, in which case the courts will treat the trust as the alter ego of the individual acting under the assumed alias of trustee and will ignore the trust arrangement completely. Okay, see Gregory versus Helvering. And it says here, mixing trust property with personal property is commingling. Okay, so it's very important not to be doing that and making sure that you do have a set of beneficiaries, because this will otherwise be classified as a grantor trust. Okay, especially if you're the grantor, you're moving all your personal assets into the trust, then you designate yourself as trustee, and then you also hold in the role of beneficiary. Okay, that's pretty obvious that you're just using that whilst having your personal account and commingling the funds. It might as well just be another personal account that you've set up. Okay, so it's so important to make sure that if you do have a personal account, keep it separate to the trust and then do everything via transfer through bill of sale, and go through the proper process of transferring assets, whether it's money or real estate or personal property, from your personal account, your strawman, and into the trust, okay, for you as trustee to keep legal title over and look after for the benefit of your beneficiaries, who should be separate from yourself. Okay, so it should be if you like your children, it could be your friends, you can set up a member association, so it could be the general public at large, based on the work you want to do on behalf of the trust, which could be educational based. The sky really is the limit. Okay, so just make sure you're not commingling. So it says here, going into, just read this again. So, but the trustee is not at all liable for any losses sustained in the proper discharge of duties. And in the case of other losses due to negligence or tort, the trustee may be able to be bonded in the manner ordinarily used by executors and administrators. They are generally not liable for contracts in which liability was properly limited, using the methods to be shown later. Such contracts may also encompass the codes and statutes of various jurisdictions, given that all man-made law is by its nature fundamentally contractual. The debts of the trust incurred requiring the creditor to look solely to the trust for payment. Conversely, the trust is not liable for the personal debts of the trustee either, except to the extent of attachability of the trustee's interest in the trust. The independent non-preventable acts of co-trustees, of which he had no prior knowledge, the acts of his agents when properly contracted, taxes on income of the trust, and lawsuits against the trust. Okay, so we've got taxes on income of the trust, footnote 96, we go down here and read this. Again, the trustee must be indemnified by the trust instrument from taxation for trust gains. If the trustee holds interest in the trust, he is taxable only at the realization of an actual gain, not at the point of investment. Okay, remember in the previous video, under the chapter of certification, with the beneficial interest certificates and the capital interest certificates for exchanges outside of the trust, there is only a tax realized when it comes to seeking profit, okay, and actually distributing funds to the beneficiaries. Because when you're exchanging property for beneficial interest certificates, there is no face value that can be assigned to it in the fiat debt currency notes. It's literally an exchange for a certificate that you hold that possesses no voting rights like otherwise a shareholder would in a corporate trust structure, okay, and no dividends or payouts unless under the discretionary powers of the trustee. Okay, so it's all beholden upon the trustee to decide as and when any profits or proceeds are going to be distributed to the certificate holders. Okay, and that's when a taxable event may occur. Like I mentioned in the previous video, when you have your status corrected and the proper entities in place, okay, if your paper's sent in, then you will be tax exempt because you exist outside of their bankrupt jurisdiction and still be able to utilize the fiat debt currency notes, okay, and have them discharged dollar for dollar, which was the promise given to us under HJR 192 with the resolution when they took away our ability to pay in substance, which is gold and silver, okay, and now we can discharge it, accept it for value, using our unlimited exemption, our unlimited credit, okay, and so that's another option too, the 1099 process. Just do it off tax returns. So in that instance, the IRS is our friend, these tax agencies are our friend, and we just got to tell them to zero the account because we have all the power to execute that because we are the executors of our trust. If we're not doing that, we become the trustees, they become the executor, they send us the bill. If we don't behave, they can lock us away and use our body as collateral because we are the trustees and they're the executors, they have all the power because we're not doing what we should be doing as a trustee role for their benefit, which is the state, which again, like I said before, that's what they claim in our name, in all capitals, the strawman. Rightio, so to carry on, next chapter, authorised representatives. So he states, as shown above, it is well within the power, discretion, and oftentimes duty to contract an authorised representative, a managing agent or attorney in fact, to deal with certain affairs of the trust. And the basic rule which courts of equity have laid down is that a trustee may contract such agents to handle all affairs which require no discretion, be they ministerial or not, and he may not delegate the essential part of a power unless, of course, he is permitted to do so by the trust instrument. Okay, those of you inside the course, if you remember on the videos that I put together with going through the trust templates that I have, you can see that there's a second trustee relationship, and within the minutes in the meeting, you can actually assign yourself the first trustee as being the managing director, again, which kind of sets up another private contract within the trust itself to allow you and grant you the powers to go about and do all the managing duties of the trust, okay, by opening up bank accounts, transferring funds, and basically giving you all the powers, okay, But otherwise, what Carlton Weiss is saying here is that you can just literally stipulate that in the trust indenture, and the trustee would automatically have those powers. Or if you wish to delegate that, you can obviously put together a private contract and hire someone else outside of the trust in order to be an authorised representative, okay, or managing agent, etc., attorney in fact. So we continue. In clarifying the discretionary power rule, it must be noted that there is no law against delegating discretionary powers to agents. The rule is simply that a trustee who does so at his own peril, for he is liable for all losses generated by the agent, if any. To clarify what constitutes the essential and unessential parts of a power, the essential part is defined as the exercise of discretion, the determining of needs of the trust, or the appropriateness of an action. The unessential part is that not requiring the exercise of discretion, etc., etc. However, there is a simple solution, allowing for greater flexibility in this rule. The solution is to authorise the agent to contract on behalf of the trust, subject to the assent of the trustee. And as noted in the previous section, if the trust instrument makes provisions for the contracting of an authorised representative, then the trustee cannot be liable for his acts. Okay, the trust indenture, guys, the trust declaration, flogging a dead horse here, whatever is put in there is the law. That is exactly the powers that are bestowed to you for you to be able to go and administer whatever it is you want to do that otherwise a sui juris, a natural living man or woman, can actually do in this world. Okay, as long as you do no harm and infringe on the rights, life, liberties and properties of another individual, you will be good as gold and you'll still be protected within the trust under your trusteeship agreement. Now, the method for contracting such agents may be either by formal appointment, if mandated by the trust instrument, or by execution of a limited power of attorney, letter of authorization, or even certificate of verbal authorization, documented by minutes of meeting. The most effective, secure method of contracting such an agent would obviously be an actual appointment with written contract setting forth the specifics of the position. But a letter of introduction is, for most purposes, sufficient, as is a simple power of attorney when the agent is acting specifically under the title of attorney in fact. So we have in the next chapter, express trust versus corporation. Carlton says, first, I must clarify, though I am referring primarily to corporations, included in the reference are all organisations which owe their existence to legislative acts, not limited to limited liability companies, limited partnerships, agencies, associations, etc. Though not classified as corporations, they avail themselves of benefits, privileges and franchises of the state for their very creation and existence. Second, since we have already shown the distinct juridical personality of the trust as a legal entity, we will not re-examine it until we consider its personality under the Roman civil law of the 14th Amendment in a later section. But it must be noted, the well-settled law that the express trust is a lawful, legal, valid business organisation with the right to hold property and sue in its business name, and its uses in modern business have some of their strongest roots in England, Germany and many of the United States, where it has been recognised for its superiority and even praised by such notable authorities as the Ohio Supreme Court for its effectiveness in the business of life insurance. It says here, I've highlighted the declaration of trust has been held to be an effective substitute for incorporation, for its many advantages, which will undoubtedly shine through to the reader by the following table. Okay, so basically what it's saying is the trust declaration itself under the common law right of contract is just as good as if you were registering an entity with the state, okay, having it recognised on the public side. So the declaration of trust has been held to be an effective substitute for incorporation. It continues, I prepared this table based upon the work by John H. Sears, who, after discussing the impact of the twin landmark cases on the grave lack of profitability of using corporations for, inter alia, dealing in real estate, went to task in outlining the distinct benefits of express trusts. The works by William C. Dunn, Guy A. Thompson and Sidney R. Wrightington are cited as well. Mr. Sears says, the decision of the United States Supreme Court holding that the express trusts are not subject to the federal excise tax on corporations has emphasized this method of conducting business as compared with corporations. The best legal talent was soon impressed into the service of devising a means of affording the usual advantages belonging to a corporation without the authority of any legislative act. A method of placing the property into the hands of trustees who hold the legal title and issued certificates similar to shares of stock to the SETI Trust, otherwise just Latin for beneficiaries, showing the interest owned by each possessed nearly all the advantages desired. This excluded the use of limited liability companies, joint stock associations, and co-partnerships, which are organised under enabling statutes, which merely enlarge the privileges possessed at common law, and they are therefore subject to state regulations, which may be equally burdensome to those imposed on corporations. Okay, and again, just to re-emphasise the meaning behind registration, regis is of the Crown, right? Okay, and it's also linked to maritime with registration for coastwide navigation and a few other things that David E. Robinson mentioned in his book, okay, in the PDF that we've gone over in the first part of the video, which I highly recommend reading, Be the One to Execute Your Trust. Okay, we'll look into that right now and see whether we can find where he mentions that, because I think it's worth bringing up. Just give me 2 seconds. Okay guys, so he says here, you may be asking, doesn't registered simply mean signed up? Well, not quite. When you register yourself, you record formally and exactly in a list or the like. Sounds innocent enough. Now, whom do you register with? With the registrar. A registrar is an officer who has custody of and is in charge of maintaining a registry or register. Some examples of registries are registries of copyrights, deeds, wills, motor vehicles, and patents. These all have to do with personal property, not people. Other registries such as of births, deaths, marriages, voter registrations, college registrations, and the like, all have to do with registering natural people. Now we are really going to take a forward leap. What really is a registry? Generally, a registry applies to vessels in foreign commerce, whereas enrollment refers to coastwide navigation. Okay, so when we register ourselves, we're saying that we are vessels in foreign commerce. Sounds ridiculous, doesn't it? This is why our names are in all capital letters on all of the various registrations when it comes to military, voting, birth certificates, death certificates, credit cards, etc. So, all vessels or ships have capitalized names. After registering, we are no longer dealt with as natural living souls, but as vessels operating in foreign commerce. Okay, so just to re-emphasize that, another good breakdown, so that it's all linked to maritime admiralty vessels, the all caps, nom de guerre, strawman name. And obviously, when you register something away from yourself, you are giving away the title and rights in exchange for privileges and benefits of the system. Okay, for them to hold the records of whatever it is you registered to them, which is your corporation. So if you're incorporating with the state, you're basically cashing in you to receive the benefits and privileges of the system they set up under bankruptcy, maritime admiralty law, for you to hold that incorporation and use that entity which they have legal title over, which is why they can tax you for its use, because it's just basically like you renting, because they're providing the privilege of keeping records for you to say to everyone else that, hey, look, I've incorporated, this entity does exist on paper and we're holding the title for you, but on behalf of us holding the title for you, you must pay us rent under the guise of taxes under usury law. Okay, that's why going back to the only entity that I've found to be able to still register with the state is a 508C1A and not be taxed and be completely tax exempt is a 508C1A and have pretty much all the benefits afforded to you as if it was formulated under private contract under the common law. Okay, which is obviously what the express trust is, and that's why it's so important, when you do set this up, that when you deal with anyone in the public realm, you are doing all these things like signing and autographing appropriately. You open up the correct bank account, which is non-interest bearing, so it's not falling under their jurisdiction of receiving benefits, which is interest in the system, okay, and a few other things, and just making sure everything's watertight and managed and administered properly under the common law right. You're right. And when you understand the post-array mechanics, which obviously the guys in the course understand this, you register this trust indenture yourself and all the agreements and paperwork yourself, assign it with the registered barcode of a registered postal sticker on the document itself, and that under the Bills of Exchange Act will lock it in maritime under international law, which is the laws of the creditors and not the debtors of the otherwise bankrupt corporations that operate under them, that owe money to the IMF and all these guys. Okay, so just a cool little tidbit on there to add in, which I'll continue with the breakdown now of the table between express trust and corporations. Okay, so we're just going to go through this one by one. So we have on the express trust side, Governed under equity, trust law is the most well-settled body of law in America. For a corporation, it's governed under statute, forever changing according to political agendas and schemes, subject to these guys, always changing under the bankruptcy laws. Trustees, express trust, trustees are sole authority, except where delegated to agents or a board of directors. For a corporation, board of directors are managers with limited defined powers to conduct business, hold regular meetings, etc. Express trust, trustees afforded more leverage and powers are generally broader than corporate offices. Law provides that whatever any individual may lawfully do, the trust can do. The sky, nature, is the limit. So for a corporation, it's relatively broad powers, such as withholding companies, which is otherwise like a trust but on the public side. However, corporations may not do whatever any individual may lawfully do. They can only do what is legal. The statute, legislature is the limit because the state owns it. They have legal title of it. They're the one that created this entity and allowed it to exist, to be recognised in their system, as we mentioned before. Express trust, trustees' liability is limited by trust instrument and by signature and all contracts and instruments. Remember Boyd and Silverthorne, trustees not subject to subpoena. Okay, so that's another advantage. So it is all private. On the corporation side, corporate offices personally liable to legislature and to creditors for all ambiguous endorsements. Remember Enron and Global Crossing cannot escape service of process. Okay, we might as well read the footnote here. So although corporate offices reserve the relative right to plead the fifth, they have merely the relative right to plead the congressionally interpreted spirit of the amendment, not the letter of the law, due to their 14th Amendment citizenship. Trustees of an express trust have the absolute right to directly refuse self-incrimination, as well as indirectly on a jurisdictional basis. Okay, you can see the court case there. And to continue, express trust, lifespan of 20 to 25 years at a time in order to avoid rules against perpetuities. Death of settlor or trustee has no effect on life or affairs of trust. Succession of power is quiet and private. On the corporation side, lifespan is perpetual or certain number of years according to legislative requirements. All officer changes must be reported, which records are open for public review. Okay, so that's quite a big one. When you do it in the public, everything's got to be kind of recorded and seen in the public, so it's not private. There is no kind of like secret trust relationship, which is what the whole idea of a trust is, for the trustee to keep secrets on behalf of the beneficiaries, and the beneficiaries not to be known. Okay, and obviously you're under the whims again of the corporation, the government, that you use in the registry in order to have this entity set up on the public side. Okay, and whatever they say, and it can change year upon year, what kind of tax filing requirements you need, how much tax you're going to be paying. So you're always subject to them. You're not in the power seat. You're a subject to the stroke of their pen, which is they're the ones executing their trust, and you end up becoming, the trustee for that has to perform because you're benefiting from their indentures, things that they put together. So express trust is not required to obtain business license. Corporations, obviously the opposite is the case. They need a license to operate. Express trust, trustees are not required to file reports with any entity and are accountable only to the beneficiary, governed strictly under principles of equity. Okay, and then corporations required to file statements and reports quarterly. Like I said, guys, the only thing that I know of that you can register on the public side and not have to file and pretty much have all the benefits of a private trust is a 508c1a ministry. Express trust, business name is naturally protected by injunction. May also use trade name or trademark for trust purposes without registration. Corporations must apply for and secure fictitious firm name and must register all trade names and trademarks. Express trust, all federal excise tax and state organization and franchise taxes are legally avoided. Corporations, the opposite is the case except for state taxes in certain states, those 5 order protection states. 5 charging order protection states, I believe it's Wyoming, Delaware, South Dakota, Alaska, and Nevada, I believe. Okay, so they've got no state taxes. So anyone in America, or around the world for that matter, if you set up a holding company there, it can be quite beneficial with a bank account. Corporations, the opposite is the case, except for state taxes in certain states. In either respect, all corporations are taxed indirectly via inflation. Okay, and there's a good little footnote here on inflation by John Maynard Keynes. And he states, inflation is a method of taxation which the government uses to secure the command over real resources just as real as those obtained by ordinary taxation. What is raised by printing notes is just as much taken from the public as is an income tax. Okay, that's in the 1980 annual report, Federal Reserve Bank of Richmond, page 10, quoting John Maynard Keynes, The Economic Consequences of the Peace, written in 1920. Okay, so it's just another stealth tax, which is, perpetrated by this fiat debt currency system, which is drawn on account of zero balance, hence why the money supply keeps inflating, which, it all has to be absorbed in prices of goods and services, which stealthily erodes away our wealth, our real wages, as it were. So let's continue. Express trust, not subject to foreign corporation laws of any state, not inherently subject to commercial regulation except for income derived from corporate stock and physical franchises under Article 1, subsection 8, clauses 1 and 3. Express trust is a valid legal entity in all states of the Union. Corporations inherently subject to all foreign corporation laws and public policy regulation. Express trust may function as an Article 4, subsection 2 citizen of the United States via its trustee, not a 14th Amendment citizen. This citizen is understood in constitutional law as the private citizen. Corporations there are 14th Amendment citizens, regardless of citizenship of corporate officer. Generally, state corporations require officers to be citizens as well. This citizen is inherently public due to the nature of the amendment. Okay, so really self-explanatory there, guys. Just giving you a breakdown as to why it's so beneficial to have a private trust set up. And it continues. So we have express trust. Trustees have absolute rights and privileges to engage in commerce under protection of the Federal Constitution. Corporations, corporate offices have relative rights and privileges to do so and incur more taxability by doing so. Express trust. Trustees issue certificates in the manner prescribed by trust instrument. Certificate holders have no say in the administration of trust affairs. And the corporations must go public in order to issue stocks. Stockholders have a relative say in affairs dependent on the extent of their holdings. Express trust. Interest of the beneficiary or beneficiaries, well protected by equity. Power to secure information as to the actions of the trustees and trust affairs is, no doubt, superior to the rights and remedies of stockholders in corporations. And for corporations, stockholders' rights protected by courts, yet the basic statutory nature of corporations allows for abuse. Stockholders are generally at the mercy of someone. Express trusts. Units of interest in the trust are not personal property of certificate holder and carry no liability as such. Okay, we have corporations. Shares of stock are personal property in the hands of owner, and taxes issue on same property against both owner and corporation. Express trust. Units of interest in the trust are not personal property of certificate holder and carry no liability as such, whereas corporations, shares of stock are personal property in the hands of owner and taxes issue on same property against both owner and corporation. So it's a taxable event, it's a taxable item that they possess. Rather, a beneficial interest certificate is not taxable unless any profits with their fiat debt currency notes is realised, okay, when it's redeemed and paid out. Like I said, if you've got your status corrected, you'll be able to bypass that also, tax exempt status. So we have it, express trust, no legal obligation to maintain the capital and refrain from paying dividends out of capital. Trust instrument governs, and with the corporations, the complete opposite is the case. Express trust may prosecute, defend litigation in trust or trustee name without compromising legality. Same rules as to parties and procedure at law and in equity are applicable. Then we have, for corporations, may bring and defend litigation in the corporate name and entity only. The process of piercing corporate veils succeeds mostly due to confusion of personal and official capacities by officers. So Carlton Weiss continues, he says, while the mortality rate of corporations and the like have historically remained high, express trusts remained, and indeed to this day, continue to remain vital. Also, as the table shows, many of the powers of an express trust are substantially the same as those of a corporation in effect, but without the legislative requirement of registration in order for those powers to be activated. These advantages and more have been and are still seized by some of the shrewdest, wealthiest individuals and families in America and from abroad. But the widely perceived yet untraceable wealth of such individuals and families like the Rothschilds, Rockefellers, Kennedys, Forbes and many of the American founding fathers, plus countless modern day politicians, are strong circumstantial evidence of this. One may find many articles and information, as well as quotes, attesting to this. Lastly, it should be mentioned that unlike the corporation, there is no lawful method by which to pierce the trust without the express permission or implied consent of the trustee, or some unlawful activity on the part of the trust giving rise to a bona fide cause of action, breach of trust. As a result, virtually no direct evidence of the trust's existence can be found unless it is made to be found by a recording. Even then, it can only be heard by a court of competent jurisdiction, which, as you will see in the sections ahead, is very hard to find nowadays. This is protection at its finest, hiding in plain sight. For as the maxim goes, Beni vixit cu beni latuit, which I've probably again butchered, but it says down here, he lives well who conceals himself and his assets well. That's an Ovid in 43 BC to AD 18. Interesting. Right, guys, next chapter. So, all this is very self-explanatory. That's a good breakdown as to, the private life and the public life. The benefits you have when living a private life and have an entity set up with an express trust such as this. And obviously, the kind of hassle and heartache and hardship you have otherwise with operating in the public. So you can use this private entity to otherwise do what a public entity recognised by the state has otherwise been, empowered to do if it is registered with them. So, next chapter, understanding commerce. Here is where we begin to address the express trust in action. As shown above, the trust may engage in all manner of trade and commerce. But before taking the step of doing so, the reader would greatly benefit the trust by understanding the nature of commerce in 21st century America. And for my brief explanation of the subtle intricacies involved, I will rely upon the two works of Lee Brobst et al. I will not go into a detailed explanation of the Constitution or the history of commerce for want of space, but I would suggest that the reader read the works relied upon herein. And I just want to finish off this footnote here when he mentions about the families setting up and utilising trust down here. So one such quote is that of John D. Rockefeller, who is reported to have said that the key to true wealth and power is to own nothing and control everything. Your author is confident that the reader will see the self-evidence of this truth, and the express trust throughout the relatively short history of America has served to facilitate this practice. A search for the assets of the Rockefeller family will prove the truth of this philosophy. And this is obviously all geared around America in particular, but there's been traces of trust being formed like this back during Plato's era in 400 BC and up to even 800 BC in Rome, in Roman times. So this is very old practice of preserving wealth. Plato did this for his university, and that was the first kind of known, properly recorded trust around 400 BC, I believe. So this has been long. This existed long before, all these families in America have been doing this too. But it's obviously been perfected and probably refined, given the changing of the times and all the statutes and the public laws that have been passed as a result of that. And normally, again, the same motive back then for putting these trusts together is in alignment with the same motive today, is to stay away from restrictive laws of the government and coming after your sweat equity. So we continue. When the trustee is engaging in trade or commerce on behalf of the trust, acting under general common law, the trust is within the jurisdiction over which the literal and absolute protections of the Bill of Rights extend, and he has no direct contact with the federal government. Under right of contract law protected by the federal constitution, the trustee may enter into the 14th Amendment jurisdiction by contract, i.e. by willfully availing the trust of benefits like the quasi-corporate privilege, franchise of limited liability for the discharge of debts, using Federal Reserve notes pursuant to the economic system established under former H.J. Resolution 192, House Joint Resolution 192. Contrast discharge with the payment of debts with standard gold-backed currency under the original Coinage Act of 1792. If you read footnote 127 here, it states House Joint Resolution 192 was tacitly repealed on October 27th, 1977, as codified at 31 US Code, subsection 5118A1 and D2. And though gold clauses have since been upheld as legally enforceable again, see Faycourt versus Frederick and Nelson, Seattle Inc., it successfully put in place a system which survived the repeal, and thus today most participants make no noticeable use of the now legally enforceable gold clause. Therefore, all discussion relating to HJ Resolution 192 remains valid in the sense that nothing has changed materially since its repeal 30 years ago. Okay, so under federal law, you are able to actually pay in gold, but because the whole system is operating under this full faith and credit of the United States and of this fiat currency that we've all agreed to just exchange promises to pay sometime in the future, that this system still exists, and because it is making a hell of a lot of money for all the creditors, the people on the right side of the ledger, right, who understand how to play this game, the banksters, why would they give this up if the people are still programmed and wanted to use it? Because it is tapping into, one of the many vices of human nature, which is greed. And they're selling us this dream, right, that we're all so captivated by through all the media and the programming of wanting to have this great big mansion, wanting to have the luxury car and living the life, going on holiday, being able to go to these 5-star resorts, etc. Okay, so it's through this where extreme inequality is bred, but that extreme vision of reaching the dream and kind of making it happen for you is what keeps people on the hamster wheel and dangling the carrot in front of them, and they never really, 99% of the people just earn enough to pay the bills of debt servitude each month of all the financing they have on all their homes and cars and everything else, because there's a massive gap in the prices and the real wages that they give us. Wages have been suppressed for 20 or 30 years, 40 years at least, ever since the 1970s. Back when under the tally stick system, I think under King Henry II, which you look up in the Money Masters documentary, he talks about how people back then, when the government were true sovereigns and they had everything backed by gold and silver, that King Henry, in order to combat the international banksters, get away from the money changers and the things they were doing to the gold certificates, with the likes of fractional reserve lending, circulating more certificates than there were gold in reserve, he brought everyone back into a tally stick system, and he passed laws to make sure that taxes had to be paid by these tally sticks. Okay, and this is when, during an era of a couple of centuries, I think, where the Gothic period gave birth to the Gothic period of all these wonderful Gothic cathedrals and architecture, because people back then only had to work for 2 months and they can afford payment on a house. And so for the rest of the year, they would often volunteer, study, and become masons and actually contribute towards public works. Okay, so it's very interesting to see the state of the world today and how everyone's still kind of captured under this illusion of Wizard of Oz, right? And that's the whole allegory behind that, taking away the gold and our ability to pay in gold. However, covertly, under the federal laws, it's stating here that it's still actually instituted and we can actually do this. But as you see with private trusts, the key for us, and as I mentioned in the previous video, is to deal with gold and silver, as you will mention later, especially when we want to acquire the allodial title of things. Okay, so if you purchase things with the fiat debt currency notes, you only get a critical use, and they're still holding legal title because you're actually using their script. Okay, and when you create a trust and you create your own society under the trust with your members, and you want to do business with other trusts, then you can actually, the best way to deal with one another is through gold and silver. Okay, so that's lawful money, and that's keeping you under the jurisdiction of common law. So he continues, under this jurisdiction, the federal government, Congress, has full and direct contact with the trust as they see fit for the benefit of public policy regulations, known as codes and statutes of this jurisdiction. This is off the back of, mentioning the HJR 192 and using the fiat debt currency system. This makes the federal government a third-party intervener in the affairs of the trust by operation of law. Because the trust, as with the 14th Amendment citizens, is being allowed to get away with not truly fulfilling its commercial contracts as is required under the common law contracts. I will show how this can all be avoided in a later section. The resulting nexus of confederacy developed under HJ Resolution 192 is an affiliation known better as an association. And the common enterprise of this unincorporated society is to offer all Americans a so-called privilege in the form of what is better known as a quasi-contract to participate in commerce without payment of debts for social security purposes. Moreover, this unincorporated society is outside the literal common law principle that demands the payment of debts as stated in Article 1, Section 10, but is allowed, upheld and protected by Article 1, Section 10 that upholds the obligation of contracts. This amounts to a federated unincorporated society by operation of law, which is contractually protected by the Constitution in the same way the express trust and its trustees are. And the trust and or trustee reserves the right to domicile themselves in the Union under Article 4, Section 3, Clause 1, and thus to contract under Article 1, Section 10, despite the fact that they cannot pay their debts. In other words, Congress cannot compel the trust or its trustee to participate in a federal interstate unincorporated banking association under Article 4, Section 3, Clause 2, and House Joint Resolution 192 for the non-payment of debts. The choice of law is up to each person still. Okay, corporations are artificial creations of the state or federal government under physical charter franchise issued via state or federal civil law for commercial regulation under Article 1, Section 8, Clauses 1 and 3. They are not under the literal common law because of the charter franchise. Any legal action against the corporation is legally called in rem action because it is against the thing or property, also called res, of the corporation under charter. The courts have automatic subject matter jurisdiction because the physical charter is the subject matter. Remember going through this in part 1, breaking that down, that they're using the in persona in order to create these legal fictional entities to then consider us and remove us as natural living beings and consider these entities they set up, these corporations, as things. It's nothing more than chattel, which can then bring it into in res jurisdiction, which then they have true ownership and discretionary powers over under their assumption presumption colouring of the law process of legal fictions. And that's where you do not want to be, because you're basically going to be at the whims of the judge who's there to execute the trust, as you as trustee who has failed to perform on behalf of the beneficiaries, which is the state. Okay, and everything, it's all a dog and pony show at that point, with lawyers trying to fight the case in order to bring you down to a lower sentence, but ultimately you sentence yourself because you've come in as the role of trustee and you've used all these benefits and privileges of the public system by incorporating within their records and giving away your titles and rights under the the crown registration. Okay, the law of visitation. So he continues, under the letter of the constitutional law, there is no commercial regulation, but House Joint Resolution 192, along with the 15 USC, brought in a third party for commercial regulation for the Social Security public policy. Remember, equity compels performance. The law views unincorporated associations as a danger to the substance of the common law because of their debt credit system. This is because there is no counterbalance to the demands the association puts on the substance of the earth, thus the reason for all the federal and state regulatory agencies. In other words, there is a presumption by implication in the civil law that a charter, a metaphysical, abstract, unreal type, exists because persons are availing themselves, volunteering, of the privileges pertaining to House Joint Resolution 192. Therefore, these persons come under a quasi-in rem jurisdiction of the civil law in order to regulate, control, including compel, those that are outside the literal common law principles. So they end up basically becoming a slave to the corporation. It's a way of them clandestinely capturing people as slaves. No different to it being, explicitly practiced back in the day when there was actual master-slave under the feudal law system. This is just a lot more clandestine, but it's no different. The many participants under this system, especially the 14th Amendment citizens from each state, together form an unincorporated federation of state associations operating under interstate commerce as addressed in Article 4, subsection 3, clause 2, and reinforced by the landmark Erie Railroad Company versus Tompkins decision. This is the basis for the federal and state government's compulsion of persons to its private international law, i.e. the spirit, not the letter, of the common law mixed with public Roman civil law, under law of nations per Article 1, subsection 8, clause 3 and 10, and Article 6, clause 2, nowadays commonly known as codes and statutes, state or federal, to regulate everything as a matter of commerce. Okay, we're looking down here at footnote 136 of what I highlighted. So now the judicial power in cases of admiralty and maritime jurisdiction has never been supposed to extend to contracts made on land and to be executed on land, but if the power of regulating commerce can be made the foundation of jurisdictions in its courts, and a new and extended admiralty jurisdiction beyond its heretofore known and admitted limits may be created on water under that authority, the same reason would justify the same exercise of power on land. Okay, see also Verlinden versus Bank of Nigeria. Roman civil law is also why the IRS continually refers to income taxes as voluntary, although to the ignorant it appears to be the exact opposite. Okay, and we got here another good paragraph which is highlighted. Without getting into the history of religion and speaking purely from an analytical perspective, the Roman civil law as a base model for commerce regulation was developed out of necessity of the church to avoid political scrutiny for its handling of ever-increasing amounts of precious metals. The Vatican. It had become a storehouse for the money and property the people were persuaded to give in exchange for limited liability, go directly to heaven instead of hell. As the people became more educated and saw what was really behind the power of religion in generating wealth, the Roman Church fell under greater and greater criticism. This led to the development of a banking system to handle and control church wealth and take the critical focus away from the church. So the banks learnt from the church about limited liability. If you could get people to borrow money beyond their ability to pay back, you could get them to keep performing, just paying the interest in one form or another on a debt to liability without ever demanding the principal back, thereby loaning out that same credit to more than one individual or company, fractional reserve banking. This meant that the bank was limiting the liability of the borrower, so he was not fully responsible for the debt as long as he continued to perform to pay in the interest. This way, real money, i.e. gold, became credit, paper money, by loaning to more than one person. Being involved in this sort of commerce was called private commerce. With the church's control over wealth, this private commerce became standard practice in world trade upon the sea. Private international or admiralty maritime law became known as Roman civil law as it began to figure heavily in the politics of every city and country it touched through international commerce. So isn't that interesting? So the church, as a result of all their doctrine and power and wealth they're accumulating, started to get a lot of political scrutiny and bad attention. So they actually set up the banking system, okay, which is basically everything goes back to the Vatican. Okay, the Vatican pretty much have all the power of all the corporations under the Roman civil law system today under maritime admiralty. Okay, and there's obviously many more hidden layers above them, which then go off world in this interplanetary corporate franchise that is going on in this galaxy, in this whole universal system. But that's where the power is. Which is why when I teach with the states correction, you have to update and notify the Vatican, okay, because they're ultimately sitting at the head and keeping an eye on the Holy See of what's going on this planet, okay, on behalf of all these human and non-human entities that are, also around conducting commerce in their so-called ships, okay. Everything's a vessel floating in the sea of space. Space is no different up there. It's all considered maritime, I guarantee it. That's why we call it starboard, okay. Just think about it. You've got vessels down here on the sea, you've got port side, starboard side. Why have you got something obviously on the right hand side of the ship is referred to as starboard? Think about it. If you're docking on a station, say a space station, on the port side of your so-called spaceship, right, that's what it's called, spaceship, and you look out to starboard, what would you otherwise see? You'd otherwise see the planet, maybe, or if you're facing away from the planet, you'll see all the stars. So it's starboard side. Okay, I'm just saying, just putting one and two together. I'm not saying that is right, but if you just follow the word, the language, etymology, it could well be the case. Okay, so it's no different, as above, so below. That's the famous saying. So, by operation of this body of law, particularly its in rem element, all persons subject to its jurisdiction are not necessarily regarded as fictional vessels per se, but are more so as objects of the state discussed earlier. These objects, like vessels in traditional admiralty practice, are vested with a distinct quasi-corporate judicial personality, but unlike vessels, are capable of suing and being sued in personam. 14th Amendment citizens of the United States, whether state or federal chartered corporations or metaphysical chartered corporate coloured public persons, therefore are akin to public vessels of the United States within the broad meaning of the Public Vessels Act and are regulated accordingly. The United States, as with the Roman Church, is considered in international law as a ship of state. The express trust, then, is akin to a private vessel of the United States of America, navigating through the often hostile waters called interstate commerce, which is international commerce via the United States treaties. Okay, so going back to the first video, that's why it's so important to fly your flag, have a seal of office, create your own flag. You must have your flag or your seal, which is the same thing. State your intent. What are your values? And have that image would then be associated with your trust indenture. So that will be a representation of your trust and the intent of your trust, which will be obviously an express private trust, to be protected in the private, but have all the powers afforded to anyone, sui juris, who can operate in the public. And so that's a public announcement on the maritime waters, which is maritime law. So if you have a vessel on the sea and you're not flying a flag, you are committing a crime, a commercial crime, and they can penalise you and prosecute you for that. Okay, that's why you see a lot of whatever ships are being sailed on the actual seas here on planet Earth, you'll see their ensign is otherwise indicating where it's been registered to. A lot of these super yachts, of these billionaires, you'll see ensigns of the Cayman Islands or the Isle of Man, because they are tax havens. So when you register something to a state that doesn't bestow tax upon anything you obviously otherwise hand over title and rights to, then it's tax exempt, which is why you see a lot of them registered with these places. Okay, but if you create your own flag and you register things, you're effectively creating your own nation, and the constitution of your own nation is otherwise a trust indenture, and then you can have in there tax exemption. There is to be no taxes in my nation, in my trust, and then you can go out and acquire an actual shipping vessel, okay, and then have the allodial title or the manufacturing statement of origin transferred, claim title ownership of that, have that transferred into the trust, where you can then make an ensign of whatever your trust seal is, your flag, and have that flying on the vessel to let everyone else know on the open seas where this vessel is from. It's from your trust, okay? It's from your corporate, not your corporate, but your private trust indenture agreement, your trust declaration. And that's all these other corporations are, these so-called countries. They only exist on the two-dimensional paper realm. There is no land deed of the United States Corporation, of the Isle of Man. It's all existing on two-dimensional bits of paper. That's where their constitutions are. Okay, so you can literally do exactly the same as what all these countries are doing, but under a trust. That's otherwise what these countries are. They're just an express trust, right? But very complicated. They've got all these sub-departments, managing agents and third-party contractors from the banks to keep an eye on their business and their beneficiaries, okay, and their trustees, make sure the trustees are performing, which is otherwise the 14th Amendment citizen. Okay, so you get the picture. Should get the picture by now. Just keep going over the material, keep reading through until the penny drops, because when it does, there's no going back. There's only one way you're going to head, which is freedom for yourself. You don't have to rely on an external saviour to do it for you, which I believe is a huge deception that's programmed into the masses through religion, and that's what they know. MK Ultra, mind control, get everyone sitting on their hands, praying that someday, sometime, someone's going to come and save them. When people don't realise that they are their own saviours, they have to save themselves. They must step into uniting with their inner Christ. That's the whole point of the second coming of the Christ. It happens within, in ascension, right? It's bridging and connecting that unique connection that every single one of us has with Source, which is otherwise just a higher self, a higher dimensional aspects of ourselves that are more, as you keep going up and up and up the dimensional scales, are closer and closer and closer to the original intent and being that is the creator of all creators. Okay, so yeah, I'll stop my preaching anyway, but we shall continue on the next chapter, doing business. So even though the express trust is technically not a business trust, within the established meaning of the term, this in no way prevents or inhibits the trust from engaging in all manner of business the trustee is permitted to under declaration, and it need only obtain the franchise of a business license if it anticipates doing express business in the above described jurisdiction. The trust may operate a business, acquire a business, sell or otherwise dispose of its business, or even contract under the limited liability system and become a taxable entity. The choice is yours. The only thing which may bar the trust from conducting a particular kind of business in any certain jurisdiction is the public policy of that jurisdiction, regarding which it has been admitted most states have not passed upon the subject directly. Okay, so footnote 142, no state has ever made any attempt to prohibit express trusts, i.e. impair the contract rights of persons sui juris. However, many states have attempted successfully to prohibit associations. Regardless of the nature of the business, there is a due notice rule which confers a duty upon the trustee under equity. The rule consists of two parts. The first is that he should sufficiently distinguish and represent the nature of the trust of the party with whom he is doing business. It is of the utmost importance in the forming of business contracts that full disclosure be made on all letterheads, business cards, checks, bills, and order blanks, papers, etc., so as to prevent any claims of lack of disclosure from arising in the future. But prudence dictates that a trustee must not disclose every fact regarding the trust, its declaration, and its affairs. The first part of the due notice requirement can be sufficiently accomplished simply by employing the designations: irrevocable express trust organisation, express trust organisation, or organised under declaration of trust, beneath or next to the trust's name. It must not be excessively revealing about the trust. The trustee has a duty to protect the privacy of the trust, has to keep secrets. It also must not be misleading. The trustee has a duty to not compromise the integrity of the trust. He is in no way prohibited from exercising the utmost shrewdness. Okay, and again, this is so very important in regards to intent by operation of law. How are you operating? How are you seen to be operating, right? Is how you're going to be treated. And you have to do that through your announcements, everything you do when it comes to signing and filling out your letterheads and your envelopes, and the way you go about business and even talking. Okay, you must become the change you wish to see, and you must take all these actions on board through the operation of the trust that you set up. You must act, you must talk the talk of a private trustee and walk the walk of a private trust trustee and do all the things that are necessary. The second part is that he should stipulate in plain and certain language in all written contracts and obligations that the trust only is liable for its obligations, and that neither the trustee nor interest holders are to be held to any personal liability in the contract. He may also wish to cite the provision of the trust which so limits his and or the interest holder's liability, but this is often unnecessary. And the trustee should always designate his title either under or immediately next to his name and signature. Okay, we just got another footnote here, which is an extension of footnote 142. We'll just read the highlighted text. The court found that because the defendants were acting under mere association, as opposed to under declaration of trust, they were an association unlawfully exercising a franchise within the state, acting as a corporation, therein without being legally incorporated. Express trusts may engage in any manner of business allowed to individuals as a natural right. Okay, it's just hammering home more of these key principles that, is going to make sure that we are operating as a private trust, as I mentioned before, not considered a partnership or an association or grant or trust, as an alter ego. Okay, and making sure we are, under the operation of law, being seen as a private express trust. So the trustee should obtain a mailing address for the trust, and though he is the principal and holder of the trust property, it is generally prudent to refrain from mixing the trust affairs with his own. He should also obtain all separate business necessities, telephone service, utilities, etc. for the trust. Logic follows that he should do these things regardless of whether he is operating trust business or not. He should, for all intents and purposes, maintain a strict separation of the trust's identity from his own, and that's so very key. Okay, you must relinquish anything you have under your strawman name, and make sure you keep everything clean and separated and transfer it into the trust, and then just operate from the trust. Own nothing, control everything. Okay, so almost don't disregard the strawman entity. You can keep it there, so you can use it for other benefits within the system, but primarily just use the trust and make sure you don't commingle. So keep separate bank accounts, separate records, and make sure that you as a trustee on behalf of this trust entity, which can be your name. You can do it in your name. It's up to you. You can just have a completely separate name as well that you can just make up. Okay, it could be linked to your surname. Like for myself, the Middleditch Family Trust. That could be the name of the trust. Could be something completely different, the Aquarian Trust. So whatever it is, just make sure you keep things separate under operation. And there's also another thing you can use, which is a digital mailbox that you can have set up, which is going to afford even more anonymity and privacy when dealing with anything, with sending letters to and from the public agents and agencies in that regard, and you can have that mail then forwarded on to where you're actually residing, which is where the address of the contract for the trust indenture will be established. Okay, but you can even establish this under the mailbox address, because it's simply a function of postal road mechanics, so it doesn't matter as long as it has one address in there that you've been able to send through the postal network under the UPU, which will grant it international jurisdiction. You can do that through a post mailbox as well, as long as you put down in the res the actual address of the property held in trust that you have every right as trustee to reside in, as mentioned before. So we have the next chapter here, limiting liability and risk. We'll just punch through these next few chapters and we'll have a look at the time and see where we can squeeze this in, but we'll probably make a third and final video just to finish off what Carlton Weiss has to say. Okay, so limiting liability and risk. In all contracts, as we have already noted, though it is best to always apply it, the trustee's mere designation of title is not sufficient to limit his liability or remove the risks to his own individual assets. Instead, he must employ the proper language either within the terms of the contract or above or beneath his signature, or in any proper place where it will appear unambiguously, indicating something to the effect of, okay, I've got obviously all the different terms of how you can sign here, but just highlighted the ones that you probably want to be using is John Doe as trustee and not personally, as trustee but not personally, or without recourse to trustee. Any form of words that will convey in certain unmistakable language to the other party that he is dealing with an express trust is sufficient notice under the rule. Whether it is necessary to also cite the provision of the trust instrument which limits his liability is a decision left to the discretion of the trustee. To quote Mr. Justice Woods in the case of Taylor versus Mayo, if a trustee contracting for the benefit of a trust wants to protect himself from individual liability on the contract, he must stipulate that he is not to be personally responsible, but that the other party is to look solely to the trust estate. And in the case of Shoe and Leather National Bank versus Dix, the court held, with regard to the promissory note made by the trustees under such limited liability, that it was not within the power of the court to change the trust liability on the note into a personal one of the trustees. That liability on a contract must be determined by the terms of the contract itself, and that a contract entered into under such limited liability, be it a note, agreement, etc., cannot be converted into one under personal liability by law. To do so would be to alter the terms of the contract itself. Furthermore, any such stipulation is ultimately subject to the acceptance of the other party in order to gain validity in the contract. Okay, so like I said before, make sure everything you're doing, walk the walk, talk the talk as a trustee, and make sure you're stating that clearly on any documents and verbally to any agents and other people that you want to contract with from the trust standpoint as trustee. So we have here banking. The trustee may open any business checking account, financial account, trust account, etc., which he is authorised by declaration to open, but you must keep in mind that by doing so, the trust will be participating directly in that unincorporated interstate banking association with all its limited liability consequences described above. There is only one type of account that avoids those consequences, the non-interest bearing checking account. When utilised in conjunction with the following banking practices, the trust and the trustee will remain out of the tentacles of public policy unless the trustee intends to play within the system. The trustee should never contract for any credit cards, and if the trust has already obtained them, rescind and cancel the contracts. Open a non-interest bearing checking account in order to avoid the privileges and immunities associated with interest. And we'll just have a look at 148 down here. It should be noted that proof of the operation of law in the manner described in the preceding sections is that banks are not required to obtain a social or tax identification number and may accept any kind of identification information they wish, only when opening non-interest bearing accounts. So we continue, maintain the minimum required balance at all times if possible and unless specific transactions demand otherwise. When transacting business, use that bank account solely for depositing the checks and keeping track of the trust funds. Never send or allow trust checks to be sent across state lines. Instead of writing checks, use postal money orders or the bank's corporate certified checks or corporate money orders when sending interstate payments, and use a bonded or non-bonded agent to establish the account on behalf of the trustee. When opening the bank account, non-interest bearing as well as any other, the following must be provided. Okay, you've got one, the original notarized letter of authorization or letter of introduction or limited power of attorney if being opened by an authorized representative, a copy of the certificate of trust, a copy of the trustee appointment, a copy of the settler's acknowledgement of trust or letter of introduction introducing the trustee. There are usually 2 introduction or acknowledgement documents per trustee, one regarding his fiduciary powers, specifically addressed to the banking institutions, and one regarding his general power to establish all other accounts. You have a copy of the first and signature pages of the Declaration of Trust. Note, the bank will almost always require evidence of a trust agreement, but the other documents may be sufficient, depending on who you are dealing with. If you can open the account without providing these documents, or with providing only a few of the documents, great. Again, this is a non-interest bearing checking account, so scrutiny is not a priority. Accounts such as this have been downplayed by banks via advertised interest rates, so most people would rather open accounts that appear to have the prospect of interest earnings. And 6, only if necessary to obtain an EIN, a copy of the filed IRS form SS4, okay, and that's something that Carlton Weiss provides for. I think he has got a letter of authorization for an authorized representative, however, he doesn't provide the trust agreements or certification of trust documents, okay, whereas that's something we have inside the course, okay, for you guys, that we should be able to see. If I can get up here under the trust documents, here we go. So all these trust documents, okay, you got the declaration of private trust, certification of execution of trust, abstract of trust, certification of trustee, minutes of the meeting, okay, executed and accepted as trustee, and the second trustee, notes to beneficiaries. So this declaration, certification, execution of trust, and the trustee meeting for banking resolution should be the 3 documents that you would need in order to go to a bank account, a bank, to open up an interest-free bank account. So, to continue, take into account the state of ignorance of the law which prevails in America today. Give only the information needed to open the account, but do not arouse suspicion or fear from lack of understanding on the part of the bank employees. If you are able to befriend someone in the institution who can establish the account more flexibly, then do it. You must be shrewd in your methods for establishing the account, since, regardless of which bank you choose, you'll be dealing with trained employees who, usually, are just a few screws and bolts away from being robots. You should consult the business tactics of successful negotiators who will all attest that the individual who needs a service is at the mercy of the provider, but the individual whose confidence and attitude subtly convey that his business is in high demand is given services, gifts, perks, not to mention any kind of account, just to get his business. It is not my intention to state the obvious, for in all business dealings, which a bank account is, one must be persuasive to get the desired results, and don't be hesitant to shop around, negotiate, bend perception, create competition. Okay, so it's so important, guys, when you go and do these things, with having your documents in hand, you must know, through knowing, you dispel fear. Okay, ignorance is, fear is only born out of ignorance, and so confidence is only gained through knowledge in dispelling the fear. And so when you have those documents, you know how powerful, these documents are when you're walking into that bank and you sit down with the bank manager and you're telling him exactly what you want, and he's going to get this done, because at the end of the day, again, he's the trustee, you're the executor, you're the principal beneficiary, you're executing the trust agreement for them to act as trustees for your bank account linked to your trust. Okay, and you've got to go in there with authority and be confident and assertive with these guys, and maybe just educate them, but you're telling them what to do for your benefit, you're the beneficiary. Okay, and so this is very important. Obviously in America it's easier if you've got the EIN, because you can actually, like Carlton Weiss shows, you can fill out and get an actual EIN, which is linked to the bank account, which will be tax exempt. Okay, linked to a private express trust, foreign citus trust, so to speak, and that will just give it even more legalities and kind of legal backing on the paperwork side of things within their public system to kind of have all the requirements ticked to open a bank account. But regardless, wherever you are in the world, UK, Canada, New Zealand, Australia, etc., or Europe, these documents, you'll be able to take in the declaration, certification of trust, etc., and sit down and open up a bank account, okay, without any other kind of legal documentation that is needed on behalf of the state, okay. And just to, another tidbit as well is if you form the declaration in any given country and you wish to open up a bank account in another country, you can get the documents, the declaration and the certification of trust are possible. Okay, and then you'd be able to take that to any country under the Hague Convention and use that to open up a bank account in another country. And so other countries may have other perks when it comes to banking, such as Switzerland. And again, think of like tax havens, right? Where you can actually take this trust agreement, and once it's apostle, it's legally recognised within all of the chartered countries under the Hague Convention, and you'll be able to go and open up a bank account in a tax haven. Okay, so that's down to you as an individual as to what you want to do given your situation. In the event it becomes unavoidably necessary to the opening of a non-interest bearing account, or if the trustee does see fit to obtain an interest bearing or other financial account, then he or an agent must apply to the IRS for an employee identification number for banking purposes. This may be done in one of the following ways. Okay, so for people outside America, you can do this via the SS4 form that you have to fax into them, or if you're an American citizen, or if you're a foreign national with an ITIN number, you can just simply do this online. It's very easy. Okay, and just follow how Carlton Weiss has the form filled out, and you'll be able to get that done. Okay, so what we're going to do now, guys, we're going to take a break. We'll end part 2, and we'll pick up on the next video on transferring assets, and we'll blitz through the remainder of Carlton Weiss's Concise Trustee Handbook. We'll skip over the legality side of things and then just finish off with the IRS relations, which is digging into even more great research behind this whole, securities replacing substance as collateral for debt. And then, the rest is up to you then to go away and do your research, get your paperwork put together, and get one of these bad boys set up, okay, for your benefit. All right, guys, thanks again for sitting with me in this. I know it can be quite painful, but again, repetition is key. Rinse and repeat. In that sense, 7 times exposure, and the more times you go through it, again, you're just going to add more spokes to the wheel, and you're going to form that whole holistic 360-degree view, and you'll know exactly what is required of you if you were to go down this road, as establishing one of these, how to administer it, operate it in the private, and benefit from all the wonderful privileges it does provide you in order to operate in the public realm. Own nothing, control everything. Okay, that's the modus operandi. That's the game. That's the objective, and that's the goal. Okay, guys. Until then, stay safe, study hard. I'll see you in the next video. I look forward to that to finish this book off. And as always, stay sovereign. Ciao for now. See you soon.